Hello, everyone. I'm here and I have no echo. Perfect. Thank you. Okay, I'm here. Can you hear me? Can you hear me? Can you hear me? I think I'm without an echo now. Oh, perfect. Thank you, guys. Thank you for the 3 of you that came back. I appreciate you. I am so sorry about that. Okay. While we are waiting for it to begin now, I will share this with you. Let me go close out the other ones real quick so people don't think we're running so many. Okay, gotcha. Perfect. So sorry about that, everyone. It has not begun yet. I have it up on my phone. So I'm just going to give you real quickly the little rundown of the case. So February 18th, and I will stop the minute. They start. Okay, I have it up on my phone so I'll know when it begins. February 18th, CPS received a call regarding 15-month-old Evelyn Boswell on February 18th, 2020. A family member told CPS they had not seen Evelyn in about 2 months. CPS caseworker made contact with Megan Boswell. She claimed Evelyn had been with her father. Here we go. Hi, Teresa. I've been dealing with some. No, I can't hear it over there. Hold on. We're not getting sound. Can you hear it? You can hear the background noise.
This case will take up the state versus Megan Boswell 72869. Long delay sentencing.
There she is.
Filed April the 4th, 2025. A jury convicted Ms. Boswell of this case will take up the state versus Megan Boswell murder in count 1, first degree murder in perpetration of felony in counts 2 and 3. The jury Senior
There was a
Level Life.
pre-sentence report filed April.
Jury also convicted her in count 4 of aggravated child abuse, count 5 aggravated child neglect,
A jury convicted Ms. Boswell of
count 7 through
first degree murder in count 1,
false
first
report,
degree murder in
count 19,
perpetration of felony in counts 2 and
count
3.
20, failure
The
to
jury
report, death and
sentenced her to life.
unusual or unnatural circumstances.
The jury also convicted her in count 4 of aggravated child abuse, count 5 aggravated child neglect, count 6 tampering with evidence, count 7 through 17
Because
false report,
sentencing,
count 19 abuse of corpse, count 20 failure to report death and suspicious, unusual or unnatural circumstances. So we're here on counts 4 through 20 for sentencing today. Is the state ready to proceed?
We are, Your Honor.
Is ready to proceed?
Yes.
Because sentencing, the first thing that's up, the state's.
How are you going to handle this?
Because of the nature of this case, there's going to be exhibit. I normally don't make any exhibit, but I think.
Thanks, sir.
Okay, copy of it. It's not been marked up. If you don't, I've got it in the file. I just got to find it. Which file it's in?
don't say that includes.
Commissioner, before we call Sheriff Cassidy.
Judge, say that approved.
Commissioner, the state will call Sheriff Cassidy.
Double check your name and where you're employed.
Jeff Cassidy, Sheriff of Sullivan County Sheriff's Office.
How long have you been with the sheriff?
Been with him a total of 29 years, my 7th year as sheriff.
And so that means you were sheriff in 2020 during the time of the war. Is that right?
Yes, ma'am.
And I'm gonna take you back to February 2020. Was Sullivan County the first agency to be involved in the investigation of missing child Evelyn Boswell?
Yes, ma'am.
Can you tell me briefly how Sullivan County how the investigation started?
Missing a child at first, and then once we found out that the last time the baby was saw was in December, we knew he was already behind the curve there. We was probably 2 months away from utilizing the resources that we needed to rescue or recover baby Evelyn.
Okay. How old were you told Evelyn was the time the investigation began?
15 months.
Okay. What was your role in the investigation?
Of course, as a lead agency, I always stay in contact and communication with all my detectives and everybody that was responded to this scene and responded to all the tips across pretty much the region. So, I was constantly in communication with TBI, FBI, and my detectives.
Okay. If you had to give an approximate number, how many Sullivan County employees do you think were tasked with working this investigation?
Aside from my executive staff, which is about 14, we had probably an additional 40 worked around the clock just on this case.
When you say around the clock, was there 24/7 coverage
Yes, ma'am.
of this? And we're talking about from the day she was reported missing until the day that she was found?
Yes, ma'am.
So approximately 18 days.
Yeah, from about February 18th to March 6th, I've looked through our records, and just overtime hours alone on this case was 740 hours.
Okay. And that's employees working their regular shifts plus overtime.
Plus
essentially.
overtime.
Okay. So let me ask this first. Did Sullivan County end up requesting the assistance from other agencies?
Yeah, this was a unique case. Normally we work most cases on our own, but we had to pull resources from the Tennessee Bureau of Investigation, Federal Bureau of Investigation, Virginia State Police, SBI.
What is the SBI?
State Bureau of Investigation, and then we had Tennessee Wildlife Resource Agency, and then multiple local regional jurisdictions up in North Carolina and other states in Middle Tennessee.
Okay. And is that essentially from following tips that were coming in?
Yeah, anything that came through, we followed every lead, try to look into everything that was brought to the VCC, which is the Virtual Command Center through Tennessee Bureau of Investigation.
And is the virtual command center, that's where the tips would come in to decide how to then send them back out to be investigated?
Yes, ma'am.
Okay. With these different agencies and with Sullivan County, what types of resources were you able to, what did you utilize to try to find this baby?
We utilized every resource that I've ever even been involved in that was at our disposal. I mean, we took jets to different places to expedite the finding of any type of information that may lead to the recovery of Evelyn. We utilized everything the TBI and FBI provided us with, just anything that was at our disposal. And we probably used more resources for this than anything I can ever remember.
We know that one of the stories, false reports that the defendant gave was that a person by the name of Ethan Perry had Evelyn. What did you have to do in regards to following that lead? What resources were used?
Yeah, he was in the military in Louisiana, from what I remember. We had to send some detectives up there as well.
Okay. And we know another story that she gave was that she kept hinting at Mendota, Virginia, over and over. Is that a lead that you also use resources to follow?
Yeah, United States Marshal, I left that out. United States Marshals helped us out on that one in Mendota.
Okay. She also told you that Angela Boswell, her mother, had Evelyn at some point. Did you follow that lead?
Yes, we worked extensively on that one. We thought that she may have had custody of baby Boswell, so we that went into North Carolina, and I think the dive team went into the ponds over there as well.
Okay. So in preparation for today's hearing, you were asked to review Sullivan County records regarding this investigation, is that right?
Yes, ma'am.
And the records that you reviewed, were they all maintained by the sheriff's office?
Yes, ma'am. Just the Sullivan County Sheriff's Office.
And the purpose of those was to come up with the manpower that was used,
Yes, ma'am.
to get an approximate amount of manpower and overtime hours, is that right?
Yes, ma'am.
What if the defendant had told the truth on day one?
Yeah.
Objection calls for speculation.
I could ask you a different way. Would you have found Evelyn if the defendant had told the truth on day one?
Objection
Yes.
calls for speculation.
Sustained. Yeah, you need to rephrase it. Too long.
If you had known that Evelyn was dead on day one, would that have changed the way you conducted your investigation?
Absolutely.
Okay. Would all of these resources have been used?
No, ma'am.
Were you aware of community involvement during the time of this investigation, the 18 days of investigation?
Yeah, extremely. They really provided us a lot of additional resources that not criminal justice related, just like they brought us food to the office so we could, eat and still work. And they all pulled together during that time and just showed tremendous outpouring of support for our entire agency. And, across the nation, really, this was a national recognized case. So the people around here in the community, they started Evelyn's Army, and they provided food for us daily.
Based on your own personal observations, what did the impact on the community look like to you?
Very emotional, just like my staff. I mean, everything you see, people wanted to find this baby, and that was their number one goal. And, whatever it may take, whatever it may need, whatever resource may need to be utilized, everybody was willing and able to put in their time, effort, and energy to locate baby Evelyn. And, just like my staff, I mean, the emotional toll on them, the lack of sleep, but they never did get fatigued. I tried to send some home, and they said, no, I'm not going home. I'm going to work on this case until we find the baby.
Okay, no other questions? Please
Thank
answer
you.
any questions Mr. Scott has for you.
I don't have any questions.
Thank you. Thank you.
Okay. call, take the next place. You're Matt Price, is that correct?
Yes, sir.
What is your position at the sheriff's department?
I'm Lieutenant in Criminal Investigations.
And Lieutenant Price, you very familiar with the investigation involving the disappearance and death of Evelyn Boswell, is that correct?
Yes, that's correct.
What was your role in the investigation?
This case was assigned to me as the lead investigator with the sheriff's office. So I was the lead investigator.
And you worked, the sheriff has testified to, you worked hand in hand with numerous agencies in the investigation, including the TBI, is that correct?
Yes, that's correct.
Okay. David Gratz at the time, also two of you
Worked it.
worked extensively. That'd be
Yes.
correct. You familiar with the evidence that was collected in the case, the discovery of the body of the victim, Evelyn Boswell?
Yes.
Lieutenant Price, I'm going to hand you some photographs. I'm just going to do this one at a time so for the sake of getting these exhibits in. I'm going to hand you the first photograph, ask you if you can show us, identify what's shown in that photo.
Yes, this is a photograph of looking inside the playhouse at the trash can where Evelyn was located.
And is that a true and accurate depiction of
Yes.
that scene?
Okay.
Judge, we would move to make that exhibit number one to this hearing, two, I'm sorry. And I don't know if it's helpful, but that is what the trial was introduced as exhibit number 15. If that's helpful or would create confusion or.
Just it'll be exhibit one from that sentence.
Two. You recognize what's shown in the photographs that handed to you?
Yes, I do.
What is that?
Again, this is looking inside the playhouse at the trash can after the one of the bags had been removed off the top.
Okay. Is there anything of significance that you see as you look at the trash can itself?
Yes, it appears that the items inside the trash can have been compressed.
Judge, we would move to make that exhibit 3 for this hearing. Okay. Lieutenant Price, would you take a look at the photographs being handed to you and ask, or again, ask if you can identify what's shown?
Yes, this is a picture of the inside the trash can with the blanket removed where you can see baby Evelyn's leg.
Is that the first shot or first, I guess,
Yes.
discovery of the body?
It is correct.
Judge, we would make that exhibit 4 for this hearing. You recognize what's shown in that photograph?
Yes.
What is it?
This is the trash bag that was inside the trash can where baby Evelyn was located, and also the child is with the aluminum foil and the blanket is laying beside the trash bag.
So the body has been removed from the trash.
Correct.
bag.
The body's been removed from the trash bag. It's in the trash bag with trash in it. Baby Evelyn was laying there wrapped in blankets and aluminum foil wrapped around her.
Judge, we would move to make that exhibit 5 this hearing. recognize what is shown in the photographs that's been handed to you?
Yes, I do.
And what is that? Picture of it.
This is the body of baby Evelyn after she was removed from the trash can, placed inside of a body bag. She's lying there with blankets wrapped around her and aluminum foil wrapped around where her head area was.
Judge would make that exhibit 6 to the scene. You recognize the photo that's just been handed to you?
Yes, I do.
What is shown in that photo?
And this is baby Evelyn laying in, still wrapped in blankets laying on a body bag, with her arm exposed, showing the onesie that she was wearing.
Is that photo, that, well, the photos that was taken at the time the body was recovered?
It is correct.
Judge would move to make that exhibit 7 to this hearing. Lieutenant Price, do you recognize what's shown in that photo?
Yes, I do.
What is that?
This is baby Evelyn after the blankets and aluminum foil have been removed from her body. It shows the position of her head and how she was laying when the blanket was removed.
Judge would move to make that exhibit 8 to this hearing. And finally, Lieutenant Price, can you do one more photo and ask you to identify that photograph, please?
Yes, I can. This is a picture of Evelyn, one of the last known pictures. We know that when she was alive.
Judge would make that exhibit number 9 to this hearing. Thank you, Lieutenant Price. If you would answer any questions Mr. Scott has for you.
No questions, Judge.
That's all I have to say.
Judge, it's Boswell, I'd like to make an allocution.
Oh, she's on the stand. I agree. They need a picture of Evelyn
I
up
would
there.
just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
Wow. Still no remorse or accountability from her.
Judge, the state has, prior to this hearing, filed a notice of intent in regards to enhancing factors that we believe apply, as well as a notice of intent to seek consecutive sentencing, which is what we are asking the court to do. And we believe, based upon the seriousness of the offense, as well as the fact that Miss Boswell is a dangerous offender whose behavior indicates little, no regard for human life, that she had no hesitation about committing a crime in which the risk of human life was high. This court should bring those sentences consecutive to each other. And I want to touch briefly on the enhancement factors, and primarily on the one that I think just screams out in this case, which is the violation of trust. Truly, I think the facts that were involved in this case, and the court, of course, consider everything that was presented and that came in the trial, as well as the photographs that have been introduced to the sentencing hearing, which again, those were all part of the trial evidence as well. But the trust that Miss Boswell betrayed upon her daughter was just so callous. She chose herself repeatedly, time and time again, over her child. All deaths are horrible, but for a small child to die in the way that Evelyn died just shows such extreme callousness. And those photographs show you. I mean, she was discarded like a piece of common garbage. To take Lieutenant Price testified to, it looks like the body has been compressed, pushed down in the trash can, so we can fit more trash, more garbage on top of a child. But probably the most hurtful and severe part of this whole and painful part of this is the fact that all that occurred at the hands of the one person that she should have been able to rely upon and trust to protect her own mother. But Megan didn't do that. Megan repeatedly chose Meg. Megan chose her life. Megan chose living in the big house out by the lake. Megan chose going to the movies. She chose going to Blowing Rock, going to Gatlinburg, again and again and again, over her own daughter.
Who's that sound like?
In order for the court to find that the defendant was a dangerous offender and apply consecutive sentencing, there are two things that the case law has said the court has to find. One is that it relates to the severity of the crime. And I can think of nothing that would be any easier than to relate consecutive sentencing to the facts of this case and what Ms. Boswell did. I mean, not only did she murder her own child and then go about her own life, but then once law enforcement was finally brought into the case, not because of her, not because she did anything, but because it finally got reported by her dad. Well, then she manipulates law enforcement, it manipulates the community by continuing to lie over and over and over again, causing extraordinary resources to have to be involved for weeks trying to find this child in the hopes that she's alive. And then even after that, even after she finally coughs up the fact that her child is dead, she continues to lie about not knowing where she is. When all along, she's sitting there stuffed upside down in the trash can in her childhood playhouse. So I think it's very easy for this court to find that the severity of this crime and her suffocating her own child, putting her in a trash can, and then repeatedly lying about it to cover it up relates to the severity of the crime. The second finding this court has to make is that it was necessary that consecutive sentencing was necessary to protect the public from further crimes. And provided the court, as well as Mr. Scott, with the case of State v. Taylor, which was a case in which a small child had been beaten to death. And then the mother basically delayed in reporting, calling 911, which eventually resulted in the child dying because she didn't receive any medical attention. And the court in that case found that the dangerous offender classification was satisfied because the defendant had demonstrated extreme callousness towards the health and welfare of the victim, and the results were fatal. Well, Judge, I really, it does not get any more callous than what the defendant did in this case. You know, she turned her back, she turned her life, she turned her trust away from her own child. Evelyn got in the way of the life Megan Boswell wanted to live, and so she eliminated that problem. It truly does not get any more callous than that. So the state would submit that both those factors are met and that the court should impose consecutive sentencing. I've already touched on the element as far as trust being involved in the enhancing factor. And then sitting here listening to Ms. Boswell's rather brief allocution, I think it's also right for the court to consider the fact that she sits here today in this courtroom still having absolutely no remorse and taking no responsibility for the death of her child. Once again, she wants to make all of us victims in the case, make herself a victim. Sheriff's office, I guess, should be issuing an apology to her for the way she's just been unfairly treated during this whole process.
Like Lori Daybell.
Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly.
Boom.
Her 15-month-old child never had a chance because of the one person who should have protected her. For that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on. And we would ask that they be run consecutive, Judge. Thank you.
Judge, I guess I'll address this in somewhat through Mr. Harper did maybe the backwards fashion. Ms. Boswell had no prior criminal history when the case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she comes to this court. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything and not run consecutive. She'll be in jail until she's 69 years old. So the court then has to determine, is she, at that point, is she going to be a threat to society? Society needs to be protected from 69-year-old Megan Boswell. The court should, I guess first the court has to consider the length of the sentence. She's a range one offender as to each count. The court should impose I think the sentences, short of a sentence is as necessary, so the court is supposed to do. To achieve the purposes of sentencing. Here, she's serving a life sentence. She will be eligible for parole at 69 years old. So how much more do you need? Essentially, the state asks you to sentence her to life without parole. That's what they want. And we have addressed that issue already in a manner of speaking. 25 years, and that's the only jury sentencing I've ever done. But the jury had the opportunity, after hearing all these facts, to consider whether to sentence her to life without parole or life with parole. They sentenced her to life with parole. And I know you're not bound by that on those other counts, but I think in fairness and in deference to that jury, we have to give some respect to what determination they made. And they were aware of all the other charges. Obviously, they heard the guilt phase and those who convicted her. So I think that is important to consider. She's eligible for probation on all the other charges. The court has to make a determination whether or not those sentences should be suspended or served. The court has to make a determination whether, if they are served, how they're served, consecutive or concurrent. As it relates to the dangerous offender who society has to be protected from, I think the case law is quite clear. Not every person convicted of first-degree murder and another felony is going to fall into that category. Normally, in a lot of the cases you see multiple victims, multiple acts. Here, all those things kind of go together. And I guess the other thing we have to talk about is what counts merged together in a sentence. I would suggest that the murder counts merged together for one count. That the child abuse and child neglect counts should merge. And that all of the following false reports should merge. Because I sent a case to you yesterday. State versus Smith, 436 Southwest 3rd, 751. This is Supreme Court decided at 2014. It talks about cases just like this. Each of these cases, these interviews were basically a continuation of the other interviews. And based on the rule of leniency, the court found that even though in that case interviews were made over multiple days with different officers, just in this case they had merged. And that's what I think should happen here, is all those counts should merge. And I guess finally, I want to address what Mr. Harper said about Ms. Boswell's comments. I think a lot of defendants would probably feel that way. But I think she's entitled to maintain her defense. She doesn't have to come in here for purposes of sentencing and somehow take responsibility. The law doesn't require that. That's not one of the factors to consider for consecutive sentencing. That's not one of the factors to consider for length of sentence. The defendant has a right to maintain their innocence, and to hold that against them and somehow sentence them to more jail time because they don't come in here and say, I did it. That violates due process. It violates the right to trial by jury, the right to appeal. So I would suggest to the court that the appropriate sentence here should be bottom end of the range. The sentences should run concurrent, and ultimately she should be left with a chance of parole when she's 69 years old. However that is structured.
Parole at 69.
Court will be in recess for 15 minutes.
Okay, you all. So they're asking to merge some of her counts. Let me mute them. So her attorney is asking them to merge some of her counts, that she will have parole by 69. And he says it is not her duty to come in here and take accountability for the courts. So poor Evelyn. They want her terms what they're hoping for, the prosecution is consecutive terms, meaning she won't fulfill them at the same time. Once she finishes one sentence, she will begin another instead of fulfilling sentences at the same time. Boy, she got up there and spoke. It was so quick. She said she didn't get a fair trial. If the state of Tennessee had been fair to her, she would have been acquitted because she didn't kill her baby. And she started crying and she got off the stand. Kind of like Lori Vallow Daybell. She stood in Arizona and talked about the accommodations not being appropriate for her. And you know what I said? Okay, Paris Hilton, you know, I hope they make an example out of her. And Robin, I thank you for being in here because I know this isn't easy for you. And I want to thank you for being in here. Anyone who's lost a child at the hands of another, I'm so sorry for your loss. And I do hope, Janet, they make an example out of her. Yeah, her crying, I think we're all beyond her crying because we saw the interviews where she cried and lied and cried and lied and cried and lied. And this girl has been in prison. She's been locked up for almost 5 years, as she should be. Because you know what? Evelyn was locked up. Evelyn was wrapped in tinfoil, wrapped tightly in a blanket. The marks were on her face. It was so tightly, she was so tightly wound, then put in a trash bag and face down in the trash can. They do believe, if you watched any of the trial, that she was alive when she was put in that trash can. She had many stories. She was first arrested for lying to the police. She said the baby daddy had her, and it turned out through this case, the baby daddy was lied to. He was not the father. She lied saying her mother had the child. That was a lie. She sent them on wild goose chases, all while Evelyn was face down in a garbage can. Evelyn couldn't get out. Evelyn couldn't. Let me just turn on a little bit of the sound so we don't miss anything. Oh, there's Salterbeck. Okay. Evelyn couldn't get out of the trash can. Why should Megan get out of the jail cell, the prison cell? So I want to look up one thing. I'm looking up where she'll do her. She was transferred after convicted to let me get the name right. West Tennessee State Penitentiary, which is 40 miles north of Memphis. So she is in a penitentiary. She is in a prison. She's 40 miles from Memphis in West Tennessee State Penitentiary. I want to look up a little bit. Just want to show you real quick, and I'm watching on my phone so we won't miss when they come back. But this is the penitentiary where she is. Let me get it back up here real quick. Okay.
I can turn it off.
Okay. This is the West Tennessee State Penitentiary. It's located in Henning and it is a time building facility. let's see what that means. A time building facility with an operating capacity of 980 inmates. It houses male offenders with custody levels. Well, males, why would she be there then? Male offenders with custody levels ranging from minimum to maximum. Now, I wonder why they sent her there. And there's the warden. Let me make sure. West Tennessee State Penitentiary, yeah. That's interesting. So it houses male offenders, but that's where she was sent. What do y'all think about that? That's interesting. Minnie said Florida prisons don't have air conditioning. Well, I think that's one less bill the taxpayers have to pay for their comfort. And I hate to say it that way, but that's just how I feel. Like when we had Tent City in Arizona, they sat out in the 115, 20 heat and they had fans blowing the heat all around. And they ate green bologna and wore pink jumpsuits and pink undies. Minnie, that is considered small, isn't it? But Minnie, do you know why they would put her at one that houses male offenders? Okay. That's not right. Okay. Got it. She's at that was a wrong ad. She is at the Deborah K. Johnson. This is where she is. They had wrong reporting on there. I'm glad we looked that up. Looked that up. She's at the Deborah K. Johnson Rehabilitation Center in Nashville. It serves as the primary diagnostic center for females in Tennessee. The prison has a capacity of 817 inmates and houses female offenders with custody levels ranging from minimum to maximum. It houses Tennessee's only female death row offender. It was originally known as the Tennessee Prison for Women. The facility was permanently renamed in August of 2020. Maybe that's why that reporter got that mistake a little bit. But she is at the Deborah K. Johnson Rehabilitation Center, according to Tennessee.gov, and she will be, there's the only person on death row there. And the jury, sorry, y'all, I'm trying to get some things to you here real quick. The jury had recommended, let me share this with you real quick. Life in prison with the possibility of parole after 51 years. So when does the 51 years start, right? Did it start 5 years ago? Is it going to start today? So we'll see if they give her sentencing for what she's already been in for. I'm not sure how this is going to go down, but 51 years, parole after 51 years. 51 years. So she does look much thinner. She has not exhibited accountability today, and her lawyer says she does not need to. Her lawyer says she does not need to sit on the stand and claim accountability. Probably from the day she was arrested, Minnie? Okay, thank you. We will see, huh? Women's Wear says UK prisons, they get tablets, Xboxes, TV, radio, 4 square meals a day, and a weekly allowance in rubbish sentences. Wow. 4 square meals a day? That's more than the normal person eats. That's craziness, Women's Warrior. Xboxes? Wow. So you know what? When you hear things like that, think about people who can't make it out on their own financially. They don't have things like internet, television, tablets, Xboxes. That's almost like enticing to create a crime, in my opinion, for some of those people, because that's a place for them to be and have everything they couldn't get on their own in the outside world. And for some people, that's worth it, in my opinion. Yeah, that is crazy. Minnie says, Minnie works at a prison, so she knows this stuff. They will add the time served and reduced by the amount of time she's been on. Okay, thank you so much. And I'm trying to find out. She's a young girl, but I want to find out exactly how old she is now. Yeah, Minnie, it sounds like gravy, doesn't it? And while taking 4 square meals, I mean, that's wild, because that's more than we're told. We're supposed to eat 3 meals a day. Why are they getting 4? Do they get special snacks too, Woman's Warrior? It's good to see you, by the way. So little Evelyn, she would be almost 7 now. Think about that. She was 15 months old. She would be almost 7 now, meaning she would be starting 1st or 2nd grade, depending if she started at kindergarten at 5 or 6. She didn't have a chance to even reach her 2nd birthday. Robin, I agree. You can't rehabilitate someone who does not think they've done anything wrong. Robin had said, if you're in the bushes, she'll never be rehabilitated. And if you don't think you've done anything wrong, how do you get rehabilitated, right? She also had told the story that her and her boyfriend were sleeping. So she blamed her mom. She blamed the baby, said she was with the baby daddy. She was with her mother. And then she finally said, while they were sleeping, her boyfriend rolled over her and smothered her. And that baby girl is just so precious. For those of you just coming in, let me share that with you, this beautiful little girl again. There she is. I don't believe there is a jury in there, Robin, but I can't speak for sure.
Evelyn. Hi.
Precious.
Mwah. Mwah.
They're still on break. There she is, the little angel. Woman's Warrior said, I know a lot of addicts who commit crimes so they can go back in. Yes. So I know that we've heard in the past that people who get out don't know how to reintegrate themselves in society. Oh, hold on, the sound's back on. So they commit another crime. Hold on, let me get back to the court. And we're not hearing them again.
Determining the appropriate sentence for these offenses. The court has considered the evidence presented at the trial at this sentencing hearing. Pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made as sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the courts as to sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, where with range 1 being 2 to 4 years. The abuse of a corpse is a Class E felony, and failure to report death under suspicious, unusual, or unnatural circumstances, also a Class E felony. Those Class E felonies for range one would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancing factor 3, that the offense involves more than one victim. I think for purposes of this case and all the proof that I heard, I can understand how that argument could be made, but I'm not going to find that enhancing factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old. I think she was 15 months old when she was found. My recollection of the proof was that she was approximately 13 months old when she went missing. Is that wrong?
Her approximate age at death was 15 months old.
Oh,
She was 15 months old.
It was 13 months old at death. It was 15 months old. They assumed when she was reported.
Right.
When they didn't know she was alive or dead.
So at the time of her death, she was somewhere between 13 and 15.
Yes.
hmm.
The state has, and the court accepts enhancing factor number 4. Number 5 is urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from the 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby is your baby. So the court accepts number 5. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. Defendant had no hesitation about committing a crime when the risk of human life was high. The court accepts number 10. And then 14, the defendant abused a position of private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. Next, I have to consider mitigating factors in determining the appropriate length of sentence. And again, I'm not going to read, there's 12 statutory mitigators under 40, 35, 113. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, is required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. If the defendant, because of youth or old age, lacks substantial judgment in committing the offense, the proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court upon hearing the evidence that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading.
Who does that sound like?
Quite frankly, circumstantially, from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision to remove that stumbling block. And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. She exercised judgment. It wasn't good judgment, but she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th is any other factor consistent with the purposes of the chapter. And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, when the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing, when the court weighs the enhancing factors and the mitigating factors, that's how I arrive at or not a verdict, but a sentence. I do want to talk, I want to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs, quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity for those 2 counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight to the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion, in counts 4 and 5, that the sentence should be 25 years. The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's been giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of the child. So counts 7 through 17 all merge into one count. So they all merge, counts 8 through 17 merge into count 7. In count 19, the courts of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the courts of the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And of course, ruling, I just so clarify, it wasn't a mistake, but at the time it was filed, we would have all the false report counts. Criminal history, obviously, since the court started, more duplicitous than it exists anymore. So we're not relying on that.
The court objection. The court also relies on enhancer number 4 from the same statute, 40-35-115, that the defendant is a dangerous offender whose behavior indicates little to no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But it's pointed out in State versus Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the big main case is the Wilkerson case, 905 Southwest 2nd, 933, Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 4035-115, enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a sentence, consecutive sentencing, is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first. There's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake, a lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravated. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child. The court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart. And then would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the, so in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar, you had indicated that you would like to have a transcript prepared before In order to prepare the motion for the trial,
Yes, Judge.
I'll order that transcript, whatever order I need to sign, Sheriff. I'll do it.
Judge, I would also like to have this sentencing period as well.
Sentencing hearing will need to be typed up as well. We'll set this for status. We'll send Ms. Boswell back to TDOC. And let's set this for a status on January 16th to see where we are on getting the transcript prepared.
That's fine, and I'll leave Ms. Boswell's appearance at that.
Well, what I prefer her to do is appear by Zoom.
That's
If
fine.
if she can, but if not, yes, we'll. All right, that's all.
And off she goes, and we'll talk about what they, look at her, she still has that smirk, rolling her eyes as she walks. Wow, okay. And we will go over what was said. Goodbye, Megan. So the status hearing is January 16th. She will, the court prefers she appeared via Zoom. Let me go ahead and change this, and we will talk about what was just said. Hold on one second. Sorry, y'all. There. Okay, so from what I could hear, because it was a little hard to hear, let's go over what the judge said. He said there were several counts that he was merging, and he started talking about the filings, and he said that the judge said Megan Boswell exercised judgment. She knew what she was doing. She wanted a new life. That's what we're going to go. I'm going to kind of go over it. It sounds like it was life plus 33 years. And the first 25 years of that 33 years needs to be served, but she might be able to get parole for the other 8. But he wants that to be evaluated because of the seriousness of the case, no remorse for her baby, and no empathy for Evelyn. Okay, so it sounds like it's life plus 33, if I'm getting that right. And 25 he wants of those 33 served. So let's go over what he said, just so we can understand a little bit. So he does not think, he does believe, the judge believes she exercised judgment. She knew what she was doing. She wanted a new life, the house on the lake, and Evelyn was an obstacle. He stated that the first 1 through 12 mitigating circumstances did not apply. He was rejecting them. 13, stating she had no criminal history, 1 job in her life. And he said she was working at the time of the unaliving, but they will give her credit for her lack of criminal history. Now, you heard him speaking of enhancements, and I looked that up for you. An enhancing factor is something that increases or strengthens a particular phenomenon or process, depending on the context. So they're saying certain acts and behaviors enhanced the charge against her. Okay, and the judge addressed those as well. He said that, let me come back to you all. The judge stated that regarding the aggravated abuse, the statute talks about children under the age of 8. receiving severe bodily harm or death. The judge brought up the point that Evelyn, although she was under 8, it is enhanced by the fact that she was a vulnerable baby. She relied on her mother to get through the days. Yeah, she got a new life, all right. Good one, Linda. So she relied on her mother. So they enhanced that a little bit because of Evelyn's age at the time. Reliant on the mother, can't get through a day without her. They trust their mamas. Okay. Then he said that regarding her Class A felony, it was 15 to 25 years, and this is what he's talking about. And the enhancements, in his opinion, take that to the 25 years. And he wants that 25 years served. The 8 years he believes are serious enough that she should serve them, but he wants for sure those 25 of the 33 served. He said it plays great weight that the baby was so young. But he did give her credit for not having a criminal record. He said he is not giving her weight because of her age, because she was well aware of what she had done. So he merged count 5 into 4. Now, we didn't get to see every count, but I'm explaining to you what happened. Regarding the tampering with evidence, she got 6 years. Oh, I'm sorry. She got the enhancing factors. She got the 25 years. Tampering with evidence was 6 years. He said the mitigating factors, very little weight. They're not going to apply. False reporting. It's usually 2 years, 2 to 4 years. It was taken to 4 years through the enhancing. Okay, because of the circumstance for her situation. Then he brought up another incident. Excuse me, I'm sorry. He said, he was talking about her not being honest and lying. And he said, it's not just a continuation of the interview that she gave where she was saying, oh, I just want my baby back. I know where she is. She's at a campground with my mom. He said, it's not just about that. It's the interviews, the officer's serious concerns from Evelyn's, the entire disappearance, the entire circumstance. He said she's told so many lies on different days to different people and different stories, but that doesn't mean it wasn't one incident, the disappearance of Evelyn. So he merged those together too. They're not going to minimize her. In other words, in my opinion, they're not going to minimize her lies. They're going to put them together. Her lies count, even though if they were to different people, even though they were different stories, different days, it's all accounted towards Evelyn's disappearance, those lies. Let's see. He said count 19, it was going to be enhanced from 1 to 2 years, which is another enhancement. He did not say the count at that one. He said count 20 will also be enhanced to 2 years for the same reason. They'll be merged. Counts 2 and 3 merged into 1. So she got 2 years from 1 to 2 because of the enhancements, the seriousness. He addressed the consecutive sentences. He said he rejects, it said that she had an extensive criminal history. The judge did reject that, and they explained, we couldn't hear much of what they explained as to why they wrote that at the time back when they were searching. Enhancement number 4, charge number 4 was enhanced because the mitigation number 4 was enhanced because there was no regard for human life. She committed this crime. No regard for her daughter's life. Also, they needed to regard the safety of protecting the public because this was a severe offense. He said evil was lurking. She's a dangerous offender. And anyone who sat through those trials knows the facts. He did not want to go through them again, but he said she was suffocated, tightly wrapped in a blanket, tinfoil, head first in a trash can. There was no doubt, no hesitation on Megan Boswell to unalive her because she wanted to live in the house on the lake. The court has not once seen remorse or empathy. He said she is a very, very dangerous offender who the circumstances and commission of this offense, he said, are definitely aggravated because Evelyn relied on Megan for her care to get through those days. She trusted her mother. He said that they brought up, well, do you really want to put a 69-year-old on parole out in society? Meaning what they were saying was, would we really at her age now, her defense was saying, serve till she's 69 and then go out into society, meaning they were trying to get that down from 69 years old. But the judge said, you're right. We have to protect society. He said she was unconcerned of the death, and she is a dangerous offender, and evil lurks. Evil lurks. I love that he said that. He said she demonstrated extreme callousness for the health and safety and welfare of a child victim, and it was a fatal result. He read that in a passage, and he said this passage was almost written to describe this case. She got 25 years for aggravated child abuse, 6 years for tampering with evidence, 4 years for false reporting, 2 years for abuse of a corpse. Now, the judge did say the 25 years, the 6 years, the 4 years, and the 2 years could be concurrent, but consecutive to the life sentence. Wow. So it sounds like she's going to be serving life plus 25, but he wants her to serve life plus 33. So life plus 25, from what I can see here, is what she is going to have. Really life plus 33, excuse me, but wants her to serve 25 of those 33. And they will be consecutive to the life sentence. So Megan, with her smirking still, her crying, she's much thinner. She just doesn't represent herself well. And I agree with the judge. That baby relied on her. It wasn't a child who could get her own snacks. It wasn't a child who could do for herself. It wasn't a child. Evelyn is not a child who could go do anything without an adult. And that trusted adult was her mother who let her down, who treated her as an obstacle, as the judge said, to a new life. And that is so heartbreaking. And we know Susan Smith did the same thing. She unalived her 2 boys, claimed they had been kidnapped, strapped them into their car seats, jumped out of the car and rolled them into a lake to drown to their death. All for a man who didn't even want her. And there was a biological father who would have taken her and would have taken the 2 boys and wanted them desperately, just like Seth Rogers wanting their child. When there's another parent, I don't understand why these people just don't hand them to the other parent. We have not found out who the biological father is, Women's Warrior, that I know of. She was a little baby, and the monster you're looking at with the half smile, she's always got that smirk. But she really thought she was going to get away with this. But I don't understand why she would leave Evelyn on her father's property, Evelyn's grandfather's property, and think she would get away with it. And remember when if you watched the trial with us, they were hold on my wrist. I'm going to put my wrist real quick up. Let me elevate it real quick. I'm so sorry, guys. Remember if you went through the trial, you saw when they were entering the kids' playhouse where they found Evelyn, they also found things of Evelyn's that were tossed in there. So it was intentional. She was doing away with her daughter for a house on a lake. And what I want to say is, so many of you in here said you would have adopted Evelyn. Some of you were trying to adopt Josie Wells. Some of you have spoken of all not being able to have children and watching these children taken, unalived. There's so many other options. We also have where we can drop children off, babies off, instead of unaliving them. And not be, you can drop a baby off. You don't have to unalive them. There's always people who want a child. So please, we've got to stop this. This Megan ruined Evelyn's life and her own. And these grandparents, the family, they have no Evelyn anymore. Evelyn isn't entering second grade. She's not in second grade right now. She's in a grave because a distorted, twisted, evil individual, selfish individual didn't protect her, but took her life so she could have a better one. Yes, wonder if she's smirking now. She's probably doing her little fake crying in her cell. And we did look up, for those of you who didn't get to see it, we looked up that she was in the, what was that? She's in Nashville in the Deborah K. Johnson Rehabilitation Center. And there's about a little over 800 inmates there. Now, my question is, what rehabilitation do they offer? Right? Well, let's look. Here's how I feel, though. If you have someone in there who isn't being accountable, is she really going to do things to rehabilitate herself? I have a feeling, in my opinion, she's going to be a handful. And I think we should really watch her record while she's in there. Like we did Susan Smith's. Remember, we would track her record of her behavior. Well, we can do that again with Evelyn and just see how she's doing in there. Because I don't think she's going to be well received. Let me put it that way. But she can get, through community partnerships, she can get an associate's, a bachelor's, or a master's degree program through Lipscomb University. Now let's talk about that. Think about all the people who want an associate's degree, a bachelor's degree, or a master's degree and cannot afford to get that. This is being offered to them, to her. Okay. An associate's degree program through Tennessee Higher Education Initiative and Nashville State Community College, computer information technology and cosmetology certifications through Tennessee College of Applied Technology, the BEST, which is building entrepreneurship for success in Tennessee. So the BEST program is offered to them, empowering individuals with the knowledge of starting their own business upon release, giving them the knowledge of being great employees and giving back to the community. Wow. We want them rehabilitated if they're going to go back in society, but I feel like they get options like degrees that others can't afford. Thistle on the inside is a sister community to Thistle Farms that supports incarcerated women through informed care, healing, and a structured place to live after release. Finally, the facility operates a transition center located directly across the street from the main compound in Nashville. The transition center is specifically designed for women who will soon be released. They provide short-term transitional services and allowing offenders to work toward gaining a job, life skills that will assist in productive reentry into society. Now, that being the case, she won't be there till she's 69 about. So imagine that. And she deserves it. I wouldn't trust her with scissors either. I wouldn't trust her with anything. She's not honest. She's still not accountable, and she's not honest. And for those of you who asked, could she get parole? Could she get parole in the state of Tennessee? Let me answer that for you. Let me share this with you. Okay, let's share this real quick. In Tennessee, well, let me go ahead and take our banners down. I apologize. Thank you to Court TV for streaming that for us. In Tennessee, while admitting guilt is not a formal requirement for parole, and this was asked because if she's eligible for parole possibly at 69, is she going to be able to get it if she does not admit guilt? And that was a fabulous question. Yeah, Leilani Simmons. Great. You know what? Maybe that's something we should do. I'm going to look that up too. Let me write that down. That's a great question. Leilani and Megan. We'll track them a little bit. Their court. We can already track some of Leilani, so I'll look into that. That's a great question. Thank you. If she gets out, she'll be going to a nursing home, in my opinion. Exactly. She'll be so old. So in Tennessee, while admitting guilt is not a formal legal requirement for parole, denying guilt can significantly harm an inmate's chances of being granted release. The parole board's role is not to re-adjudicate a case or determine innocence, but to assess whether the inmate has been rehabilitated and would be a risk to the community. Well, the judge thinks she is a risk to the community, obviously, currently, right now. How a denial of guilt impacts a parole decision. And this is specifically Tennessee. Lack of remorse. Refusing to admit guilt can be interpreted by the board as a lack of remorse or inability to accept responsibility for the offense. Perceived risk. A lack of remorse or insight into one's crime is often seen as an indicator of a greater risk to public safety. So she lowers her chances of parole because she raises her chance of being a risk to public safety without remorse, if she does not have remorse. Focus on rehabilitation. The parole board's primary focus is on assessing the prisoner's rehabilitation. Claiming innocence can undermine this process as it suggests the inmate did not need to be rehabilitated for that particular crime. Oh, so yeah, if she's not admitting to it, how is she rehabilitating herself for that crime? Legal limbo. For an inmate who maintains innocence, seeking parole puts them in a difficult position. Admitting guilt to enhance parole chances could potentially harm future efforts to appeal or overturn the conviction. So let's say that again. For an inmate who's maintaining innocence, which Megan is, seeking parole puts them in a difficult position. Admitting guilt to enhance parole chances could potentially harm future efforts to appeal or overturn the conviction. So if she wants to appeal, she can't admit guilt. She's not admitting her guilt. But if she wants parole, she's in a difficult position if she's still standing there maintaining innocence. There is a narrow exception for those who maintain their innocence, but it is a challenge. It is challenging to achieve. So there is a little bit of room to get paroled in Tennessee if you maintain your innocence, but it's challenging to achieve. An inmate asserting innocence may need to demonstrate to the board that their claim is plausible and based on reasonable evidence. And I don't know how Megan would do that with everything we saw in that trial. However, even if a claim is considered plausible, the board may still prioritize public safety concerns over a potential wrongful conviction. Okay, so even if her claim of innocence is plausible, they can still deny her based on safety to the public, concern for the public. So for all these reasons, even without a formal rule requiring a confession, inmates who continue to claim innocence face a substantial disadvantage when seeking parole in Tennessee. So what's she going to do? Yes, Menendez got turned down by the parole boards because they had cell phones and they felt they were above the rules and the law, still exhibiting that. And that was that was not just cell phone uses. There were a couple of other things, but the cell phone usage was huge because they said that exhibits that they're not willing to follow the rules of prison society. Would they follow the rules of our society? They were denied, and they can come back in 3 years. By the way, did you see Eric's face? In front of Eric's face, it broke my heart. And I'm not saying anything. I just broke my heart. His face was just so upset when I was watching that. And people are gone, so this is serious to the victims, right? Now, the difference that the Menendez brothers had is the family who were the victims, their family members were the victims. Many of them, most of them, there was an uncle who was not, but many of them were supporting the boys being released. And that is the victims' families. And they still were denied because cell phones and things. So if she follows the rules in there, we will watch and see. I kind of doubt that Megan will, in my opinion, because Megan doesn't seem to think, in my opinion, from what we've heard from her own words, that the rules apply. She makes excuses. She tells lies. She laughs it off. She blames others. She blamed the boyfriend for rolling over Evelyn after they determined the biological father didn't have her. They had to determine the grandmother didn't have her. Then when they found out she was deceased, she claimed that the boyfriend rolled over her while they were sleeping and she was suffocated that way. So if that's the case, why would you foil her up, wrap her in a blanket, put her in a garbage bag, and put her face down in the trash? But that was her excuse for the autopsy report, that Evelyn was asphyxiated. I don't think she thinks rules apply to her either. So it's just heartbreaking. Evelyn should be in 2nd grade. Evelyn should be having interests now, knowing things she likes and doesn't like, thinking about making little friends, holding the hand of her teacher on the way out to the playground. I know you all know I taught middle school, but I also have taught kinder in 1st grade. And one of the things I will never forget about loving teaching kinder in 1st grade is when it was time for recess, you'd have 12 little ones coming to grab your hands because they all wanted to walk out with you. They're innocent. They're vulnerable. They trust you. They rely on you. But that was my favorite part. When I taught 1st grade, I taught with my best friend, and we just loved it. We'd come out with handfuls of children and play with them. And there's no reason for this. And she is a dangerous, evil person who still does not admit she unalived her daughter. Justice for Evelyn Boswell. We are 5 years down the road, but she is now sentenced and she will remain there. I will like to watch her record. I want to, 69, when she's 69, my goodness, I hope she doesn't get paroled. But I'm still wondering why, and I want to look this up because I don't remember from when the case was going on, why they did not go for the death penalty. Hold on. Do any of you remember that? Because they have the death penalty. They have the death penalty, and I don't recall why Evelyn wasn't. Let me Google it. A lot of times we'll see them. Oh, yeah, it's already out here. Okay. So life plus 33 years. We were right. See, we got it right, guys. Life plus 33 years is what she got. Still claiming She didn't do it. Still saying Tennessee isn't fair to her. Well, guess what? Were you fair to Evelyn? Why should you get out? Could Evelyn get out of that trash can head down, face down, still breathing? Could she get out and save her own life? No, she couldn't. So I wonder how the other women in the prison, do they have her protected? Is she in general population? I'd like to know that. There's a lot I want to know now, and I'm sure a lot we're going to hear now that the sentencing has been completed. I want to hear how, is she in general population? Are they protecting her? How are the women treating her? That's what I want to hear, and that's what I think I'm going to start poking into too. And I will look at Leilani's record in prison for you too. I've written that down for an upcoming show for us. So I want to thank you all for being here. I know I lost so many of you when I had the echo going on before the court started. So for the few of you who came back, I want to thank you. And for those of you in the bushes, thank you so much. There will be justice for Evelyn because her mother will live in captivity now. And I say that because she, you think about an animal when they're captured, right? We say they're living in captivity. I think Megan Boswell is an animal, and she is now living in captivity. Thank you all for being here. By the way, I will be coming out with an update. It is hi, Tearjerker. Love your name. Rest in peace, Evelyn. Absolutely. And I will be back later today. I am definitely going to do a video. And I just wanted to tell those of you who are following Sebastian's case, Sebastian's army is expanding. So hit that thumbs up, the notification bell, so you don't miss what I'm going to talk about later. Okay. So we have a celebrity posting about Sebastian now, and we had the FBI posting yesterday. So I will come out with a video on that for those of you who didn't want to watch the 4-hour live that we did. So hit the notification bell. I'll be on a couple more times today, probably one time live, one video. Okay. And then don't miss it, please. I want to be able to share with you that Sebastian's army is growing. People are starting to post about him, speak about him, very high profile people, the FBI, and another celebrity. So prayers up for all the little ones missing, for all the little ones whose family don't know where they are, and for all the families who are dealing with the loss of a little one at the hands of another family member, whether it be a mom, a sister, an uncle. It's just a tragedy, and it's happening far too much. So we're going to keep an eye on this little one while she's in prison and see how she does. Thank you so much for being here. I will see you probably 9 p.m. Eastern for my live, but I will be on with a video prior to that. So thank you so much for being here. Justice for Evelyn Boswell. And stay safe, be aware of your surroundings, and keep keeping on, my friends.